All right, so we talked about last time around in Intro to Mock Trial Part 1 about a courtroom and how it's set up and kind of discuss roles and goals of everyone who is inside of the courtroom. So now we're going to talk about how an actual trial itself looks. So a trial is the seventh of 8 steps in the criminal law process, and the trial itself has multiple parts. It can take anywhere from a couple of days to a couple of weeks, even stretching out to a couple of years. It just depends. All right, so here's how it looks. The bailiff says, "All rise for the Honorable Judge so-and-so." Judge walks in, takes their seat on the bench, because remember last time we talked about the judge's place in the courtroom is nicknamed the bench. The judge asks everyone to be seated. They introduce the case, the people versus O.J. Simpson, the people versus blah, 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 and they read out all the charges. Now, in the case of the Parkland, Florida shooter at Stoneman Douglas High School, he has been charged with 17 counts of murder one, or of first-degree murder, premeditated murder, and a few other charges. So rather than saying one count, first-degree murder, 17 separate times, the judge will say 17 counts, murder one, and move on about their business. All right, so here's what actually happens when the good stuff starts to happen. This is witnesses and evidence and I object, all that good stuff. All right, so the prosecution always goes first. The prosecution is offense, and then we have the defense, which is obviously defense. Okay, so prosecution will give opening statements, and we'll delve into those here in a little bit, and then the defense. So 1 and 2, it always goes back and forth. The prosecution gets to go first again. They bring up witnesses, they ask questions, and they include evidence. All right, they are building a case. Both sides are building a case. The prosecution brings up witnesses, asks questions, and includes evidence for a purpose in order to convict or convince the jury to convict the defendant. And the defense brings up witnesses, questions, and evidence in order to convince the jury to acquit the defendant. All right, so this happens back and forth. But a little caveat here. When one side brings up a witness and stops questioning the witness, the other side gets a chance to kind of poke holes in the other one's story. All right, so let's say that Joe Dirt is testifying on behalf of the prosecution. So Joe Dirt is an offense witness. All right, Joe Dirt swears himself in with the bailiff. "I swear to tell the truth, the whole truth, nothing but the truth, so help me God," blah, blah, blah. He takes the box, all right? So the prosecution walks up, asks Joe Dirt some questions, and then once they're finished asking questions, they'll look at the judge and they say, "No further questions, Your Honor," and they have a seat. And then the judge will look at the defense and say, "Defense, your witness." And now the whole purpose of the defense is to get up there and poke holes, as many holes as possible, in Joe Dirt's story. All right, so if you are questioning your own witness, so if the offense is questioning an offensive witness, that is called direct examination. Now, if the offense is questioning a defensive witness, that's called, I'm sorry, I think I said the wrong thing. All right, if offense is questioning offense, it's direct examination. Offense questions defense, or comes up to poke holes in the other side's story, that's called cross-examination. So you're crossing to the other side's witnesses and asking them questions. All right, and then the prosecution gives closing statements, talk about those in a second, and the jury deliberates, kind of debates a little bit, and comes to a conclusion, or maybe not. Their two conclusions are, we cannot reach a conclusion at this time, they're going to acquit them, or they're going to convict, so that's 3. All right, and then the judge is going to ask the jury foreman their decision. Rather than having 12 people shouting "not guilty" or "guilty" for every single count, one person, the jury foreman, gets chosen by the jury to speak on behalf of all of them. And then in the case of a conviction, so if you are found guilty, the judge will issue a sentence in proportion to the crime. All right, let's delve a little deeper into some details here. The opening statements are your first impression on the jury. So this is the first thing that they are going to hear from an attorney. All right, an attorney is the one who gives opening statements. You as the victim or you as the defendant do not get to hop up in court and be like, "Here's my story." All right, that's not how it works. You can record your story, and the prosecution or the defense can play parts of it depending on how they want to use it for their case. But you as an attorney are going to speak to the jury. All questions, all evidence, all opening and closing statements are directed at the jury. They are the most important people in the room. The prosecution obviously wants the jury to convict. They're going to say a short little brief summary of why, and the defense wants the jury to acquit, and they're going to speak on why. You need to be bold and convincing and make the jury think. You need to come out swinging. all right? There are links to opening statements, to discrediting a witness, and to closing statements listed on your note sheet. If you want to pause this and open them up in a new tab, that's fine, but they will make a lot more sense as to what an opening and closing statement and discrediting a witness should look like, especially when we move into our actual trial or coming up. If you will do that as we go along. So evidence must have a purpose, must have a purpose. You have to convince the jury one way or the other, and we know how prosecution and defense feel. All right, so there are two categories of evidence, direct and circumstantial. All right, direct evidence cannot be disputed. These are papers, records, financial records, bank statements, someone's phone records calling someone else across town, receipts that are found in someone's house, things like that. Circumstantial evidence can be called into question. So these are testimonies, trace evidence, fingerprints that may or may not have anything to do with the incident, things like that. Things that can be called into question and there's the story can have holes poked in it. All right, so this is someone swearing in. Now, you don't necessarily have to put your hand on a Bible in order to do this. Some people will swear on a law book. Some people will swear on a copy of the Constitution. You can choose whatever piece of literature you would like to swear on in a courthouse. All right, physical evidence is up next. This is any evidence that can be viewed, touched, or processed. All right, this must be processed by an actual legitimate forensic laboratory. You cannot just be like, I did a DNA test at my house. Okay, we can't use that in court. All right, so some examples are fingerprints, DNA, trace evidence, so a hair that's found somewhere, or a super tiny speck of blood that's found in someone's car, or things like that. Crime scene photos don't necessarily constitute physical evidence, but sometimes they can represent it if you can't bring the actual physical evidence into the courtroom. All right, so here's some fingerprints. DNA in its little bottle, and a UV light. This can be used to find trace evidence of liquids that have dried and are no longer visible to the eye but are still present. All right, so there are 8 total rules of evidence, and you must follow all of these rules when presenting evidence inside of a courtroom. So it must be presented for a purpose and used correctly. And we'll talk about the consequences if it is not here in a second. All right, so number 1 is irrelevant evidence. If the evidence that either side presents has absolutely nothing to do with you being able to, with the jury, being able to make a more informed decision of whether to convict or acquit, you are not allowed to present that to the court and have the jury see it. It's irrelevant. All right, so if you were to object to this, it'd be objection, relevance. All right, you can't lead a witness down a certain path either. This is rule number 2, leading questions. You can't kind of push or shove a witness down a certain path of questioning to get the answers that you want for the court. That's not how it works. All right, number 3 is hearsay. So any he said, she said that occurred outside of the court, an attorney has no business asking a witness about a conversation that might not be super relevant, but also there is no proof of the conversation at all, and there's no proof of the outcome of the conversation. All right, 4 is lack of personal knowledge. You can't ask a witness something that they are unable to answer because they just don't know. You can't do that. That's wasting everyone's time. All right, we've got the next 4 coming up. Number 5 is opinion. You cannot ask a witness an opinion if they are not an expert in any given field. You can't ask Joe Dirt, would you say that the defendant was mentally stable at the time of the incident? Joe Dirt is not a criminal psychologist, and that person has no business giving an opinion in court. All right, number 6 is argumentative questions and badgering. That's not allowed. You can't be extremely aggressive with a witness, and you don't need to argue with a witness. You don't need to fuss at people in court. That's rude. And also waste time. All right, number 7 is speculation. You don't need to ask a witness to guess. There is no need for that. All right, and number 8 is a specific rule that applies only to mock trial. There are no new facts that may be presented. If you as a witness get up there and whatever you say is not in your witness statement and could potentially affect the outcome of the case, you may not say that. You can't just make up new facts in order to get you, free your boy. All right, that's not how it works. All right, so if the rules are violated, the opposing counsel, so whoever is listening to the other attorney question the witness, you may object to evidence. So objection, relevance. Objection, badgering the witness. All right. So the judge has two options. The judge can either sustain the objection, so they agree with the person who is doing the objecting, like, yeah, that is irrelevant. I'm okay with that. They're going to say sustained, and then they'll turn to the attorney who is asking questions and say, please redirect. So ask a new line of questioning. Now, if the judge does not agree with the objection and they think that the lawyer is just being extra, they're going to say objection overruled. All right, and they're allowing the witness to answer the question, or they allow the attorney to continue along their merry path of asking questions. And we'll have a little practice with that later. All right, so questions have got to serve a purpose. You either support or discredit a witness, the defendant, or the evidence presented. All right, and discrediting a witness is just a fancy term for poking holes in somebody's story. All right, and if you'll watch that video, either pause where you're at now and watch it, or you are more than welcome to watch at the end. All right, witnesses are next. There are two types, character and trial. A character witness is someone who testifies about the defendant as a person. All right, their goal is to convince the jury, like if you're testifying on behalf of the defendant, you're there to help your boy out, help your girl out. You're going to say, yeah, they're a great person. There's no way they could have committed this crime, ... Okay, if you're testifying on behalf of the prosecution, you're going to say, oh, I have been in school with this person since I was in the 4th grade. This person and I had multiple altercations. They are a terrible human being. There is no doubt in my mind that they are capable of committing this crime, ... Okay, so a character witness was not there at the time of the incident. They're there to talk about the person and their personality. All right, a trial witness is someone who can testify as to who, what, when, where, why, how about the case. They can either confirm or deny some sort of detail of the case. All right, and their goal, if they're on the prosecution side or on offense, is to confirm guilt of the defendant. And then if they're on the defense's side, they're casting doubt on whether or not this person could have done so. All right, closing statement is the last thing we're going to talk about. Quick and painless. This is the very last impression that an attorney can leave with the jury. This is the only point in time where the defense going second is a beneficial thing to them. All right, they're batting last, all right, which is great. So the prosecution at this point has done their damage. They have spoken to confirm guilt for the prosecution. Closing statements usually only last about 3 to 5 minutes, maybe a little longer depending on the severity of the case. And the prosecuting attorney is going to speak on behalf speak to the jury on behalf of the people and say, you need to lock this person up, they're a terrible human being, ... Okay, and the defense is going to speak to confirm innocence, or they're going to try to justify the action of the defense, like, this person, yes, they did some terrible things, but here is why. Okay, all right, and you can watch that on your own time when you finish up. All right, this has been Intro to Mock Trial Part 2.